Hello, everyone, and thank you so much for joining us this evening for the Cheeky Natives interview with retired Deputy Chief Justice Dikgang Moseneke about his second book, All Rise, a Judicial Memoir. We are the Cheeky Natives. I am Dr. Alma-Nalisha, Cele, and I am in conversation with my partner, Advocate Letlhogonolo Mokgoroane, who we run a literary podcast whose primary aim is to archive Black literature on the continent and the diaspora through critical engagements with writers and literary audiences. Just a reminder that we won't be able to hear you, but you will be able to interact with us tonight by using the chat and the Q&A functions. We will start with the conversation for about 25 minutes, and then we'll take some questions from the audience. Please do send your questions through the Q&A function, and you can also send other messages and comments using the chat function. You can also get a copy of the book from us via our website, and Eileen from PAN will share the link in the chat. You can also get the book on Amazon, Kindle, Snapify, or Kobo.
Good evening, everyone. We're really excited to host this wonderful conversation with Justice Dikgang Moseneke. And today we'll be talking about All Rise, which is a judicial memoir, which both myself and Alma felt was a really important book, I think for lawyers, but also for non-lawyers. And I'm interested to see some of the music that Alma has on the book. So, Judge, we wanted to start the conversation here. Justice Edwin Cameron, in the foreword to the book, refers to you as a jurisprudential lover, which we think is an interesting nod, right, to this enduring power of collaborations in the space of differing views. This existence of collaboration is contrasted in the Constitutional Court and the lower courts. In the book, you do a lot of work of thinking about how the Constitutional Court, as it signifies, is like people under a tree dispensing justice. And we wanted to speak to you about, like, what are some of your reflections about the differences of the lower courts and the Constitutional Court?
Let me start by saying thank you to Advocate Mokgoroane and Dr. Alma-Nalisha Cele for putting this together. I remember saying to my publishers, if I don't speak to young, radical, thinking, thoughtful, Black people, I'm going to die. Because the book is written essentially for them. Its purchase is wider than that, but certainly it's one that hopes to make you rise. And rise in the sense of, elevating your sights and pushing boundaries and searching for new contours. So is that kind of book. As you get older, you think about what's coming behind me. Who are the young people who are going to take it from there? Yes, Justice Cameron and I often said we are, jurisprudential lovers. And we often made the joke, and we made it quite clear that we meant jurisprudential lovers and nothing else. And would often make that kind of joke. I have a long-standing wife. I am heterosexual, and he has made the selection he has made, and we are in deep mutual respect of our choices and the intellectual engagement that we offered each other. So let me go to the point that you really sought to make. Often there is the error that the apex is everything in a structure. And architecturally, as we all know, the base is indeed everything. Think about it. I spent a bit of time in the book to talk about the magistrates' court. And I say that that is where most of our people get justice or injustice. Often crowded, often busy, often less resourced than, for instance, the Constitutional Court. And because there are so many cases, and all those magistrates do a fantastic job relative to what they have as resources, starting with time, for instance. And 80% of our people, maybe 90% of people in our country, that's where they really go and look for relief. if they have to get. So yes, that is very, very important. And we have to revisit those courts if we are serious about access to justice by citizens and inhabitants of our land. That's where the tire and the tarmac meets. And we have to do more than we do. But inevitably, I worked at the rarefied space in the Constitutional Court, and I do spend a lot of time there. But I'm going to stop there for a while, Letlhogonolo. I told myself today, don't talk too much, let them talk, not you. Okay.
Thank you, Judge.
Thank you so much. I think that it's interesting that you've spoken about an era, because in the book you write about an era that was highlighted in the book, where you look at the treatment of Black advocates at the bar, and this treatment in many ways forms the basis of the transformation that you pursue later on in your career. And so in an era like now, where we're having renewed conversations regarding the contemporary realities that are faced by Black, women, and non-binary binary individuals in the legal sector and just in the corporate space in this country, I want to know what you now think transformation looks like in this contemporary setting.
Great question, Doc Alma. Let me say to you, look, I spent a bit of time to remind you that these are colonial institutions. We inherited them, right? They look natural now when you look at them. And I spent a bit of time to show you why even the common law is an imposition. Common to whom? And I explain common to our colonial masters. And they made it common to us and insisted that that would be the law. So I wanted every young person not to get there with the snotty assumption that it's all fine and well. This was an extension of the colonial project. And this will be your law. And that is why you remember, in the book I spent time to tell you, African marriages, traditional customary marriages were not recognized. Hindu marriages concluded by Hindu rites were not registered, by Muslim rites were not registered. Only those under Christian, whatever that means, rites were registered. And they had to be strictly heterosexual. So there was a collection of oppression, all shrouded all together into race, into gender oppression, into oppression in relation to sexual orientation, pregnancy, age, all of those things apartheid represented. So what I do is I take you to the bar to show you that whilst it is celebrated as this great place, and that's where Letlhogonolo now works, and he proudly goes to work there, as long as he knows that in fact there is much to be looked at carefully here, and that it's not all hunky-dory just because you have the title advocate. And I show you how the bar played a supportive role to colonial oppression, to racial oppression, and how some people, and I singled them out by name, and today I want to pay tribute to one of them, George Bezos. I singled them out by name who made it a point that they say this is an unjust society, and we will be on the side of those who seek to protect their rights. So yes, the bar needs to be, you say how far is transformation now? Not too far.
Thank you, Judge.
If you're going to look at indeed, and please go ahead.
In the book, you say you cannot merely dream about your revolutionary ideals, legitimate ideals as a good basis for society. And we were interested to know what does that look like in practice? So we know that you've spent a lot of time in My Own Liberators speaking about how you've carved your own way, and you sort of bring that idea also in All Rise. But we wanted to know how revolutionary ideals look like in practice, particularly in the context with which you've just spoken about, where most of the institutions that we exist in still have this legacy of white supremacy, of racism, sexism, homophobia.
Yes, I mean, all of those are right there, all present. And that's why the Constitution was such an ambitious excuse me, experiment. Few countries in the world, and believe me, I've been to many law schools invited to come and talk about our country, our transition, and our challenges. Few countries went as far as we did and say, no, only women have the right to decide whether they carry pregnancy. No, people may decide who they want to love or not. No, race is irrelevant. No, there'll be no gender oppression. No, everybody will have a right to vote. So we did a number of very bold things. But your question is a cutting one, because it really says, how do you identify revolutionary conduct? Now, simple, of course, definition of revolution is those steps that would irreversibly change the power relations in a society. When you turn around where the power sits and you successfully do so and keep the power at the new place, if you, for instance, take people who are disenfranchised and give them political power, that's what happened in our case, potentially that could be life-changing. And later we can talk about why didn't we change our circumstances? And I'm happy to debate that. So, for instance, if you allow people to become the holders of power, that's revolutionary. If you think through what are the entitlements of people, that potential is revolutionary, but not to be confused with whether or not steps have been taken to achieve those things. That's a different discussion, and that's the one we must have today.
In speaking about, I think that it's so interesting that you said that, Judge, that I'm thinking about disenfranchised people, and I think that particularly as it relates to the healthcare system, we see in public health the intersection between all of these inequalities that exist. And so I want to spend a little bit of time talking about life estimate as an example of redress and accountability. So what does justice and redress look like in the absence of punitive measures, such as arrest? So you've spoken a little bit about the distinction between justice and vengeance, but I want to know that in a context such as that, what does justice and redress really look like?
Yes, again, a difficult question, very, very incisive, very cutting. Of course, life as a demani, we brought onto ourselves, isn't it? It's like us doing evil to us kind of thing. It's like some measure of self-hatred at play, failing to recognize the humanity in those who are vulnerable. And people are mainly vulnerable in the health sector, in access and delivery of health. That is where optimal vulnerability lies. And we saw that with the TAC case, for instance. Shortly after our democracy, the transition, and the government would not budge. They would not provide antiretrovirals to mothers. And therefore, the potential for them transmitting the virus to their children was obvious. But no, the government dragged its feet. We had to come as the judiciary and say, but we've promised the people that they'll have access to healthcare. And therefore you can't be here to be saying anything different. And as you know, we ordered the government to do it. And that was early, it's sad, because the government should have been on the front foot to fulfill those obligations and needs of our people, needs of healthcare. In Esidimeni, people were receiving healthcare, which was abruptly terminated in very arbitrary and horrible circumstances. And the consequences were what? People died. In fact, I was saying the other day to somebody, Dr. Alma, that more people died in the Esidimeni incident than Sharpeville and Marikana put together. So it's a major national disaster where there was a dereliction of duty, and you're right, up to now, there's been no consequences.
Judge, I suppose it brings
now,
me...
nobody's been charged.
It brings me to an interesting question, which you sort of take up in the book, but, you know, allow us as the readers to be the judge, so to say. I think that's something that you beautifully do in the book. You're like, well, I've already made these decisions. How would you have voted? But it brings me to an interesting question of thinking about Mazibuko. I mean, we know that a lot of academics and a lot of social justice lawyers were really somewhat outraged by the way the court handled the Mazibuko decision. And I wanted some reflections on that to think about, like, in many instances, we think about justice happening outside of the courtroom, but because, as we've seen in Live Esidimeni, as we've seen in the Grootboom case, as we've seen in Mazibuko, what has happened is that the government is not doing what it's supposed to do. And so the last resort that people want to go to is go to the courts. But I suppose the question then is, Judge, what happens if the court decides, like it did in Mazibuko, to defer to the executive in order to do this particular thing? Does justice then happen in that respect?
Well, Advocate Letlhogonolo, I'd hope that you wouldn't take me there, because that's a weeping boy and girl of, you know, of the Constitutional Court. Everybody takes you to Mazibuko and say, but you guys messed up here, okay? I'm prepared to debate it because I voted with Justice Cato Reagan and supported the judgment. And I was asked more recently, and I said, no, but I stand by the judgment. Let's try and explain. The moment is the gap between the ideal that the Constitution set up and the conduct of those who ought to ensure that these rights are fulfilled. And we should not make that error, because that's going to be ever present. It's a little like somebody reading some scripture, some script somewhere, whether it's the Quran or the Gita or the Bible or something, and it says to you, here is the ideal standard. You can almost bet your bottom dollar that human beings will fall short of the standard. Some will disrupt it, some will subvert it. So it's always so that the Constitution says people shall have access to water. We need to look around to know that millions of our people don't have access to water. Not in the way, at least, that the Constitution envisages. Let's go to Mazibuko. In Mazibuko, a statute was passed that sought to regulate the extent and the amount of water that every household will be entitled to. The Constitution was the high-ranking law that says everybody shall have access to water. We as a court have all sorts of rules. Some are not helpful, but some are. If you're unhappy about a statute, you attack it. You must ask us to declare it invalid. It's called the Doctrine of Subsidiarity. And I don't want to talk about those things here because all rights tries to talk up to non-lawyers. So yes. Letlhogonolo, I must be careful where you're taking me to. And we took the view that as a matter of jurisprudential rule, they did not attack the statute. And therefore we cannot substitute the literage people must get. Our own choice, as the High Court did, and the SCA did, against that of the statute. And you can say we defer to the statute, but the problem was if the statute had been attacked head on, that it prescribed less water than was helpful for a family, that would have been an entirely different matter. So that technicality, that was the rule which stood in the way of giving people adequate access. And I think that is where the criticism lies. I don't want to take the evening on that. There is a lawyer debate which we can have another day, Letlhogonolo.
Thank you, Judge.
I want to bring it back from the attorneys, and I think that this is something that came up for me in reading the book as somebody who is not an attorney, and I think that it sort of plays into the earlier conversation that you have. And I want to speak about the expansion of the idea of justice, and as we begin to imagine what justice may look like. So I want to know, what does it mean to be just in unjust circumstances? So there are a few cases in the book that you speak about where you feel that correct legal decisions were taken, but these were not necessarily aligned to your personal, to your ethics, or to your own compass, I suppose. And so I really want us to speak a little bit about what it means for the law to not be enough, and what it means to really be just in unjust circumstances. So as we begin to reimagine what justice looks like according to you.
Yes, and the book does this. It goes there to say to you, law is not just a set of technical rules. Law is part of a democratic project in society. Its primary goal is to achieve what? Justice. To achieve public good, in some instances, private good. I'm going to give you an example. If somebody smashed the windows of your car, God forbid, ordinarily the law should have, then the equilibrium, what we call stasis, has been disturbed. Hence, we use a scale to often express the notion of justice. You owned a car, somebody has smashed it and diminished its value. In a good system, legal system, our hope must be that there can be a law that will force the person to make good the wrong that he or she has committed. And once they've done that, the scale goes back to where it belongs, because the unlawful act will smash the scale one way or the other. So what judges do, or ought to do, is to strive to give effect to the law. Remember that judges don't make the law. They receive the law from Parliament, from the Constitution, law-making bodies, but they have the capacity to interpret the law. And their primary duties, when they do, they must try and have a just result, a fair result. Now, under apartheid, you could be a judge, but you could never produce fair results. Give an example. The law says, no Black woman may enter this ablution block, this toilet. And you, Dr. Alma, you walk in there and you get arrested. No just outcome could be there, because the law is patently unjust. So our job is to try and close the gap between the law and justice, the law and what is fair and beneficial and good for society, whether individually or collectively. And if you can achieve that, that will be great, but sometimes you don't. Somebody's charged for rape and the judge argues reasons in a bizarre way and say, but this woman was not injured, and therefore I'm going to give a light sentence, which is a nonsense, okay? So judges' job is to implement the law. The assumption is that the law itself is just. And if it is unjust, judges often have the duty to interpret the law in a way that produces just outcomes. Under apartheid, you couldn't do that because that was a parliamentary sovereignty. Under our constitutional jurisdiction, you can do that. And we've done that quite often.
Thank you, Judge. I wanted to speak about the more personal elements of All Rise. I think that as much as it is a judicial memoir, there is an insertion of Justice Dikgang Moseneke, so you insert yourself. But I wanted to speak about the often controversial intergenerational conversation that people from my generation and perhaps people from your generations often butt heads about. And this is the Mandela years. I think that you spend quite a bit of time framing the Mandela years and reflecting about some of the conversations that younger people are having about how we see the Mandela years and how people from your generation see the Mandela years. And I wanted to, speak a little bit and pick your brain a little bit about it. What do you think it is about my generation thinking that Mandela, for instance, sold us out, and your generation thinking that that didn't happen? Because what you try to do in the book is frame it in a particular context and in a particular moment. And I wanted us to just speak about that, right? This intergenerational conversation about like what it actually meant negotiating to create the interim constitution.
Well, Letlhogonolo, wonderful. I would like to talk about that. And quite often I get called out to come and talk about that. As I did this morning, paid tribute to George Bezos, I inevitably also paid tribute to Nelson Mandela, first president of our democratic republic. Now, I'm trying to say, young people, let's not, and we must see the gains, if any, of 1994 within the context of the balance of power in 1994. Many of you were not born, or if you are born, many of you were in your nappies or running around in kindergarten, okay?
We were in our nappies.
Many of you in their nappies. Now, we don't blame you for that and for your impatience. I'll come to it in a moment. But let's recap. We had fought against colonial oppression for 350 years nearly when 1994 came. You remember? When after the settlers, African people in a variety of ways, using mainly gunpowder. In the case of Xhosa people, for instance, and Khoisans of First Nations, they're pushed over and over the Keiskamma River, K River, until they were the other side, north of the K River. And the area was said, there's your place, Transkei is yours. But they actually pushed all the way up. And as there was an incursion into the hinterland, through the Free State, Northern Cape Free State and Gauteng, there was all the way there. There were wars of dispossession all the way. 1910, the ANC gets formed. And then there the struggle rolls as they try and push back. And more militant entities like the Pan-Africanist Congress of Azania emerge, who are much more militant and who are saying, hey, bring our land back, you are oppressors. And then the Black Consciousness Movement and Steve Biko. So there's been a constant definition and redefinition of what our struggle is and what it ought to achieve. Just keep that in mind. And you guys were not here, okay? And I don't blame you for that. Come 1994, we had not totally vanquished our oppressors. Mm-hmm. They were in trouble because the economy had tanked out because of sanctions and campaigns against them. We had sports boycotts, and many of us went to prison and even came back and continued with the struggle to resist them. And internally, there were entities like the Black Consciousness Movement, the UDF, who rose against the system. And a lot of grassroots dissatisfaction came up. But at that point, when they started negotiations, they still controlled the army, they had an atomic bomb, they had a few other things that were in their favor. But they still would not have won, but they've taken us another 30, 40 years to win completely, maybe 15, maybe 20 years, okay? Maybe less. But there have also been a lot of bloodshed and so a deal was struck. All I'm saying is that the deal was struck in certain circumstances. If you win a war and you march, as you've seen in the movies, tanks and soldiers marching into a city and they've won the war, they can name the city anything. They can change anything. They can do what they like. We were not exactly in that position. But here's my biggest point, and not that one. But we got political power in 1994. Economic power, no. Did we get the land back? No. You can go down that route, that's fine. But we had the power to be able to firstly, to transform the economy. We have the power to give our young people the best education in the world so that they can go out there and be the majority of actors within the economy. And we could have funded them. We could have made sure that they thrive, okay? We had the power to expropriate land. You can ask me, oh, where to pay compensation. We can talk about that. The Constitution says you pay fair value, not market value, okay? We would have determined, we the judges would have determined what is fair value. But we did none of those things. So we must just be careful. I think what Tata Madiba did, just to leave that point, many other questions I'm sure coming. He gave us the keys to political power. Like him or hate him, that he did. Could he have given us economic power on a piece of paper? I doubt it. I don't know how you do it on a piece of paper. But you can give your followers the power to change the power relations in society. You know, the thing I talked about earlier. So there was a potential there if we had gone flat out. For instance, we, the RDP, the reconstruction program that we had at the beginning, if it had gone full out on many things, the white population at best of times was about 11% in 1994. Think about it. Now it is about 9%, 8%. So if there was the will, political will, we could have rearranged our, as we did politically. We took over parliament, we controlled it, we took over the courts. You know, today, 80% of the judges in this country are Black people. That high. It's a very transformed space in terms of skin color. We need many more gender, equality there. We need many more women. And in the book, as you know, I take time to bow and take tribute to all those women judges who started with us from 1994. And I want to see many more. And people like Justice Masipa, who ran that trial that you all looked at from home. She was awesome. You may not like his final sentence and so on. He may have made an error in law somewhere, but she was imperious. She ran that trial with dignity, with efficiency to its end, issued the judgment. And of course, as always, you may criticize the judgment. So we have done certain things in non-economic and non-socioeconomic terms. And we shouldn't beat ourselves up to nothing. And for that reason, I think the Mandela years were not a complete sellout. They had a potential to become something good, provided we used the power. Nothing in the Constitution stops economic transformation, nothing.
I want to link that to the contemporary question around land in this country. And I want to ask if you believe that the Constitution has achieved its ideals as it relates to those kinds of contemporary questions. So the question of land is one that comes up often. And do you believe that the ideal has been achieved? And if not, what would your reimagining of that achievement look like?
Yes, no, certainly not. Dr. Alma, no, it has not been achieved. That's part of my complaint. I wrote a paper which you can find time, you can just Google it and you'll see me writing about the land question. Yeah. And I spent time to analyze section 25. And Letlhogonolo is laughing, you probably have seen the article.
I have, Judge. I have seen the paper, Judge.
Yeah, it's a published article in the papers. My complaint was that Section 25 is less than perfect. And there must be land justice in this country. We can't be crowded and crouched in narrow spaces in our land of birth. And we have to take steps to make sure that our young have access to land, for starters, agricultural land and rural land. Think about when you travel to other countries. Have you been to Spain? Have you been to Brazil? Have you been to the French countryside? The most beautiful places where tourists go are their countrysides, where people make cheese and honey and the small little restaurant and the small, in other words, you go to the countryside to absorb that beauty that you often see when you drive on the N2 across the sky and KZN. So we need land justice. We need land restitution.
Amen.
And Section 25 makes provision for that. And I don't say it's perfect, far from it. I don't think it is. But for instance, we're talking about urban poverty. Most of it, Dr. Alma, is peri-urban. It's a lot of poor people who live around urban areas, right? We see them in Cape, we see them in Gauteng, we see them in every town and city. You find people surrounding the wealthier areas. And in the paper, I say we have not sweated the section, not nearly enough. Just imagine if we took that land. If it's ours, it's the government's, it's ours. If it's not, we expropriate it, and we can debate how much we should pay for it. Okay? And we cut it up. And Letlhogonolo, we survey it. And we produce title deeds. And we connect water and sewage points to every stand around where Mikuku are. We provide, and then we give every one of our people, we have enough land to do that for now. A title deed in their hand. With a title deed in your hand, what do you have? A little bit of gold, right? You can walk up to the bank and be able to take a bond on it and build your little house that you want to do and grow it over time. But you can empower. You can empower your people by each one of them having a service stand, just for starters. And there are many other ideas. So we have a duty to make sure that we fulfill the ideal of our people having access to land, both urban and rural. And we have to give them an opportunity to be able to use the land as collateral, as a place they can live for dignity, not all the pain we see every day on shots on television. So yes, the land question is contemporary. It has to be there. And some of us, old as we are, we say, yes, of course. We must take means in an orderly way as government to get land to the people. Nice big stands for every one of us, and let's lay the pipes. If you don't have the money, let's go and borrow it, but build infrastructure, right? And pave the streets and let people live there. You're going to see wonderful neighborhoods mushrooming there. And because we'd have given our people. So that's my view. It's a little too granular, but I've no doubt we need land justice. Our people should stop living on top of each other. Every winter, when one catches fire, all of them catch fire. No, we deserve better for ourselves, and we have the power. We control the treasury. We control the parliament. We rule this place. Okay.
Thank you so much, Judge. I thought that was really powerful. I suppose, Judge, before we open it up for Q&A, I have one final sort of like legal question.
There's so many followers. I see 134 of them. Incredible.
So, Judge, the question that I have is, you speak about the first judgment that you write when you get to the Constitutional Court, which is S versus Turbis, which is about common purpose. And I often explain common purpose to people who may not know it as the scene in Sarafina where these young people went and wanted to burn the Bongeni Ngema's house as the apartheid police officer. And all the people who acted in purpose with everyone else would be held liable in terms of common purpose. So that's essentially how it is. But
Indeed.
I suppose my question is this, Judge. I don't know if you've had a chance to look at Chabalala versus the state, which is the Constitutional Court judgment from last year, which dealt with common purpose in the context of rape. And I thought, Judge, that judgment really, sort of fundamentally changed the way we look at rape, because there was a whole big issue about instrumentality, that in order for rape to be held guilty, you needed to participate in the rape. But it seemed that the constitutional judgment really made a very important judgment for GBV. And I wanted to know, what are some of your reflections about that, particularly thinking about the contemporary issues of gender-based violence in South Africa?
Yes, I mean, you see, we all hated common purpose because it was used to oppress. And it is that principle. If 3 people broke into your home and only one had a gun, but all 3 come there with one purpose, i.e. to rob you and or to murder you. And all 3 are aware that if you are to resist, you might be shot dead. So in many ways, they make common cause with the crime or the outcome that would come out of the crime, okay? So under apartheid, I was charged for going to a meeting, various meetings of young Pan-Africanists who said, let's overthrow the government by force. And we made common cause, and we made with other comrades and friends who did that, and we were charged for conspiracy. It's a common plan to commit an offense. Common purpose, okay? So when I got to the court and I had to write the judgment, I had an instinctive hatred for common purpose. Think about the Sharpeville 6. They're all sentenced to death. Think about many of people who were in the Paarl uprising, so-called Poko uprising. Many of them were hung and sentenced to death. They did not themselves kill anybody, but they were part of the group that invaded. So we instinctively hated it as political activists. Now I'm a judge, and I'm called upon to look at it. And it is plain that there are many instances where common purpose would be useful to combat crime. And combating crime is something that is valuable. And therefore, if we get to gender-based violence in circumstances where people collaborate in order to get that outcome, there's no reason why they cannot be held liable of the principal crime. Odd as it might sound, you might argue, how does a woman rape another woman? Well, we can have that debate one day. But the point is, if they're part of the purpose, I haven't looked at Chabalala lately. I'll have to go and look again. So I'm careful not to go to that judgment. But for my part, one of the things that a good democratic state should be able to do, and good societies ought to do, is to afford us security of the person. Mm-hmm. It's the highest entitlement we have. It's allied to the right to life. If you have no proper right to life, as our women are often, threatened and their right to life is taken away, it's one of the primary duties to reorganize, to do our damnness to stop it. It's a very vital right. And connected to that right then is the fear to lose your life or your right to life, and the fear to be molested. So all of those things together diminish the worthy and entitlement of women in society. Mm-hmm. Or gender-based violence, therefore, is in every sense inimical to our democratic project.
Mm-hmm. We're going to, thank you so much, Judge. We're going to open up to questions, and we've got quite a few of them. And I want to begin with the first question, which says, I would love to hear what Justice Moseneke's thoughts are on the criticism that Ubuntu has no place in the adjudication of matters before the courts because of its inability to offer certainty, and because it offers too great an opportunity for judges and justices to be liberal in their interpretation of the law.
I think it has a place. I've written about it. Justice Mokgoroane more poignantly about it, and I'm one of those who have drawn from it. No, I don't think so. You see, there are two schools of thought on jurisprudence. There are those who want a rule-based justice, and there are those who would like to exercise judicial function within a discernible track. In other words, within a range. Because human condition is never black or white. It's never certain or uncertain. And therefore, our Constitution invites the judiciary to use this broad standard called in the interest of justice. It's a wide standard, way wider than Ubuntu. Ubuntu is fundamental to our understanding, particularly as African people and as Black people, of each other's humanity and how central it is. So any law or conduct that threatens the humanity and the equal worth of another and undignifies others is something that we ought to kick back against it. So Ubuntu is a valuable, it's not a rule of law. It is an underlying value. It's like dignity. It's like equality. It's like freedom. And all those are not single line laws. We have chosen in our Constitution a value-based approach to law. The other places, and Apartheid had, if you didn't have one line that says that you may enter this toilet, then you are guilty of entering the toilet. It's kind of nonsense. It's called positivism in legal philosophy. You'll see in the book, I strive to say we ought to follow a value-based, ethics-driven adjudication. And the law should never be an S. In other words, the law should never produce stupid outcomes or unfair outcomes. And that's my answer to the question.
We have a second question here, and the person is asking, what is your opinion on the recent decision of the Swiss federal courts to uphold a decision of the Court of Arbitration for Sports to not allow Caster Semenya to run the 800 meters without having taken medication to reduce naturally high levels of testosterone?
I think it's bizarre. It's totally bizarre. And I'm saying it not just emotionally, because Caster is from my country and is a gifted athlete. Look, let's turn it around. This Bolt guy who wins 100 meters, have you seen how long his legs are? And you know why he wins? Because he strides and opens up those long legs. If he had shorter legs, he probably would not win, right? And what about guys, what about people who have bigger muscles and therefore able to play rugby in a particular way, while others are thinner with smaller shoulders? Should we require those who are with bigger shoulders to take some medication to reduce their muscle strength? You see, competitions always have a margin of naturally gifted ability. And I could move on. Maybe you should suggest that Dikgang Moseneke's head must be crushed and made smaller. And you must reduce the brain in my head so that you can compete with me properly. Or make me drink some milk. See, these are innate qualities given. I don't want to say God-given, but you come along with them from birth. And they give you some edge. If you have longer fingers like me, you might be able to play a piano better than somebody with shorter fingers. Must they cut my fingers so that others with shorter fingers can compete with me? I mean, it's ridiculous. So I don't want to get to the legalities of it, but from those examples, you'll know I think the decision is patently wrong, and it disregards innate abilities. Some people can sing, some can't. Damn, you can't cut the vocal cords of those who can sing so that they sing as badly as those who can't sing. Life is about using the gifts that we have. As long as we use them fairly within certain limits, we should be able to do that.
There's another question here about your thoughts regarding the integration and the use of technology in ensuring access to justice. So there's an example given that with the pandemic, a lot of judicial hearings were pushed, a lot of judicial functions, were pushed to move online, such as virtual hearings. And so the person wants to know what your thoughts are on the integration and use of technology.
Must. That is overdue, it's over delayed. I mean, we should do it like yesterday. And look at me, old and tired as I am, here am I in front of you, trying to, to take full advantage of technology. And not only, the fancy Zoom trials, I've done a few arbitrations online, just like this with counsel on the other side. No, I'm talking also about using technology to digitize records, to have them delivered in those forms, to make sure that people have access to what's happening at the courts and create more accountability. People must be able to track their own cases as you can track your parcel. If you bought something, say, from Amazon or wherever else, you should be able to track your case online. Think about what fun it would be. Think about all records being digitized. And then they won't disappear. Quite often in the courts, you hear that somebody's just disappeared with a file. And many cases are not prosecuted and tried because of that. So it's long overdue. Besides coronavirus, it has just become an impetus. We must do it like yesterday. And we must spend some money in that direction, properly. Get people who can do it and digitize all the courts so that we can make headway.
We have another question here, and the question says, you're quoted, my obligations are what is good for the people as enunciated by the Constitution and other laws, and not what is the wish of the ruling elites. How useful is the law to South Africans when ruling elites or not? There seems to be little will to implement the Constitution and laws for South Africans, and this applies to all parts of what is right versus reality in this country. And I guess the second part of that question, which somebody has asked, would be, they've said that there's been a compelling argument, and that seems to be the premise of your book as well, and that's for civil accountability. And they want to know how realistic a call for civil activity is in a country whose results of civic action in the Constitution and democratic efforts hasn't offered what we want. So the two parts of a very similar question.
Yes, I mean, both questions have put their finger on it. On my hope, in my old age, my hope is you guys will not roll over. Let me tell you what happened in 1994. Because we had become democratic, everybody sort of folded their tents and sort of walked away. The churches, the unions joined the governing arrangements, the businesses formed associations, but basically aligned to the ruling arrangements and so on. So everybody trusted what had come out of the electoral process and looked away and thought it would all be hunky-dory. No, in the book I'm saying true change, and so revolutions are a process and not an event. They're not in 1994, they are a process. Two, active citizenry is vital. Alongside other institutions that exist, alongside the media, people should be able to say, why don't we have water in this village? And make an issue out of it. I agree that it appears as if not much has come out of it, but it's in fact because of the pressure of the people. that we saw a lot of the activity in investigating PPE corruption and other forms of corruption. In fact, so we need very active citizenry and citizenship. And you guys can and should be able to do that if you want to turn around your situations. So you're right. The premise of the book is you're going to have to get off where you are seated and really find causes that you would want to support that would help to change our world. What's happening around GBV by way of activism is lovely. Life as a Demand was made possible by activists in the socioeconomic space who kept on supporting people who were in need and needed. And therefore, I think most young people cannot lightly say, oh, it has all failed, look how terrible it looks. In one webinar, I said, maybe you guys, people like Advocate Letlhogonolo should be queuing up at the NPA and saying, I want to be a prosecutor. Sorry, I want to arrest, I want to prosecute the thieves. So it's one thing to be away and screaming about it. And you will then be able to say, it's not what my political leader wants. It is what the law requires of me. So you would not do the wrong thing. You would not give out tenders, or you would not do unlawful things only because your immediate leader wants you to do it. But we have to actually, look, I don't want us to use this as an example. In many countries, in almost all of Europe, there are no majority parties. There are coalition governments. People spread their votes the way they choose. And they do it quite often and consistently. And other politicians run around to try and knit together coalitions and things and so on. And then they can guard over each other, besides us guarding them. And besides the courts having to do all the weight lifting and say, no, you can't do that, you can't do this. So we have to, the democracy must mature and people must make choices that will best serve the ideals of our long struggle. But the youth must make those choices. And nobody can do it for you. And it has failed a little, it's all reason why it should be tried again.
There is a question around, I just need to find it, sorry, Judge. There is a question here regarding the recent cruel and inhumane evictions done in Cape Town. And the right to housing is possibly the most litigated right at the Constitutional Court and has been interpreted extensively and progressively. And yet the state refuses to adhere to these laws and interpretations. What is next, and how does the law help in that instance? And there's, I guess, a question that would go with this is there's also a question here regarding, sorry, Judge, I just want to find it. There's a question here about more women on the bench and capacitating the land claims courts, which they feel is the missing question that no one is talking about. So I think that those two questions have space to go together.
Yes, well, I've talked about it. Go look at the paper I wrote and complained. I give you statistics of delay before the land claims court. There are thousands of cases that have not been resolved. Claims that have been there for 20 years have not been processed to finality. So if you can find that paper that I delivered to MISTRA about 4 or 5 years ago, it's published, where I tell you that the land claims court is where it gets blocked quite a lot. So you're quite right. That is where we should look to and capacitate that court, but also because it is this vital thing we've talked about already, land and access to land and land and dignity. Yes, it is true that courts make very progressive decisions, but it's not always that actually the outcomes would match, what the courts had hoped for. Which brings us again to the same question: accountability. Finding ways and means in a democratic setting to hold people to account and bring a culture of accountability. Remember that the obligations that sit in the Constitution bind the executive. They bind Parliament. They don't bind the courts only. It's not necessary that the courts all the time should be the ones who blow the whistle. All those evictions have been at the instance of local authorities, isn't it? It's really local authorities that have been throwing out poor and needy people. They may or may have a good reason, I don't know. I haven't said in the case, but damn, you know, in winter, in the rainy season, or whenever, so many of our people are landless. They have no place they can call home. And they still get evicted. So the courts will keep on pronouncing and say, no, don't do it. But in the end, that obligation sits also with the executive. And it's the people who decide who becomes executive. You who decide. So it's going to become very important for us to understand all the moving elements of a democratic arrangement. And that the people are meant to hold people, those who hold public power to account. And remember, my last little parting short, democracy is premised on insecurity of tenure. Remember that line for all you young people. People are more responsive when their tenure is uncertain. And the more certain the tenure is, the less response or responsiveness you will get. And that's why elections are compulsory every 5 years, to give the people an opportunity. But the courts can't lift, and I say that in the book, the courts you can't pack everything, you know, every jacket on the same peg, because courts can't do everything. They're just 1/3 of the state arrangement. We've gone over an hour, have we?
Yes, we have. Can we take one last question, please, Justice Moseneke, and then we'll close it up. And I think that this is a beautiful way for us to close the question and answer session. And there's a question here about your words bring hope. So this person is actually writing from Seattle, and they said that your words bring hope for vulnerable groups too. And they'd like you to share a couple of thoughts of hope and wisdom for people fighting justice there.
Oh, thank you. I mean, that is really, so you have people actually participating from Seattle? That is interesting, yes. Well, I hope so. I mean, the book, as I've said in concluding, the book is a call to duty for judges. When the court starts, every time you hear all rise, it's not just about you people in the court standing up because the judge is coming in. All rise is also a call to the judge herself to start performing her judicial duties. And all rise is a call to our people to wisen and wake up to the entitlements that can help change their circumstances. But I've got news for you. It's only us, it's only the people who actually can make a difference over time. And power brokers could if they sought to, but they rarely seek to. And it's not us only, I'm talking about, look at the whole world round. I've taught in many universities across the world, and issues of injustice, of inequality, of exclusion are universal issues. We're not like us only. You can go around the world and go and see just how much exclusion, how much oppression, how much economic unfairness how means of production are not being shared and they're hogged by a few at the expense of the majority. So we are dealing with quite a human problem. And there's no exceptionalism. We're not entitled to bring South African exceptionalism. Ultimately, we're the ones who ought to hold our leaders to account, our judges to account, our police to account. We have to find ways to have them do what our constitution and other law requires them to do. And what is good for society? Forget about the law. Get them to do what's good for society. Just getting water, something so basic, something that they ought to be able to get quite readily.
Thank you so much, Judge. We've really had a wonderful time this evening. Thank you for extending yourself so generously. We just want to say to everyone who's watching, this is the book All Rise by Dikgang Moseneke. And not only because of this conversation and the wonderful insights that we've heard today, I think you want to get the book because in many ways, Justice Moseneke allows us to journey with him throughout the time that he spent at the court. And not only journey with us as voyeuristic people, but to actually participate in the decisions that the court have made and make our own determination as about what justice should look like in those particular instances or whether justice was done in those particular instances. I think the start and the end of the book are two important questions. Justice Moseneke says, I'm writing this book because I want to know whether I've dispensed justice in the way that I was called to dispense justice. So we really think that it is important for you to get All Rise, because not only is it a judicial memoir that will help you understand really the functionings of the court, but will also give you an insight into one of South Africa's a really great jurist. So thank you everyone for joining us. Thank you for joining the Cheeky Natives in conversation with Justice Moseneke. The link will be sent tomorrow. And as we've said, if you want to get a copy of the book, just head over to our website, www.cheekynatives.co.za/shop and get a book, and we'll get it delivered to you as soon as possible. Thank you everyone for joining us. Thank you, Judge.
Thank you ever so much. Thanks for having me, and I like your name, Cheeky Natives. I like it.
Thank you so much, Judge. We really do appreciate your time this evening.
Yes, no, thanks for having me, and I'm surprised there are 63 comments in the chat, section. So people have been engaging. It is just so wonderful. But I'm grateful to all of you, and it's a privilege to be in your spaces and your young minds, and I wish you well in your respective careers.
Thank you, Judge.
Good night.
Thank you so much.
God bless.